Good afternoon. Today, the Manitoba Association of Crown Attorneys has released a discussion paper to justice stakeholders outlining the changes to procedure in the Provincial Court of Manitoba that we believe would assist in ensuring Crown attorneys can effectively discharge their duty to the court when contested bail applications are made in Winnipeg. The paper outlines current practice for the bail court in Winnipeg in the Winnipeg Centre. That current practice allows for bail applications to be made with essentially no notice to the Crown attorneys responsible for conducting those bail hearings. We believe that this system does a disservice to public safety by undermining the ability of Crown attorneys to properly prepare for these hearings and to put full information before the court. If the judge hearing a bail application isn't getting full information from the Crown, they aren't able to make the best decision possible about the release or detention of an accused person. Releases made without due consideration of all available information undermine public confidence in the administration of justice. Our paper outlines 2 recommendations for court procedure that would ensure reasonable notice to Crown attorneys about which matters will be going for bail on any given day, and also ensure a more efficient use of court resources. We hope that the discussion paper we released today will spark a conversation about how to more effectively run our bail courts. We don't pretend to have all the answers, but we want to make a contribution to the discussion that is happening about bail right now in Canada. That discussion should be grounded in the law and in information from frontline prosecutors like ourselves. We believe that the notice period we're asking for will adequately balance those needs and the accused charter right to a reasonable bail. Beyond those changes, we're also calling on the government to ensure adequate and dedicated resources for bail court to ensure each Crown attorney has the time available to properly review their matters in bail court and to advance the Crown's position in front of the court when we're opposed to the release of the accused. We're also calling on the City of Winnipeg to ensure that adequate police resources are available to assist Crowns in vetting bail plans. Many plans proposed by counsel for accused persons aren't properly scrutinized, and Crown attorneys aren't in a position to look into these plans in substantive ways. Police are better suited to make those inquiries into the plans offered by the accused, and our association would like to see police resources dedicated to vetting bail plans. We're happy to take your questions.
Can you walk through, in the release, you kind of talked about that the day-to-day grind. Just in your words, what's that like?
Do you want to start, Brooke?
Sure, I can start. Do you want just like first-person perspective of walking into the court? Okay, so when I am bail Crown you're assigned for a 1-week period, and you head in, and one of the main problems is that when you step in the door to court that morning, you have no idea what it is that's going to be proceeding that day. Bail court is essentially the only place where that happens. When it's a sentencing docket, we know the matters we will be speaking to that day. If it's an application being heard, any other type of court you step into, you know what you're speaking to that day. Bail court, you don't. There's nothing on the docket in front of the judge. So you walk in, and at 9:30 is that triage court. That's when that begins. That's in a separate room in front of a justice of the peace. And in that room, they're determining what's going to be put into the bail court before a judge. We are each responsible for, you heard about the AC, the adult custody docket, as well as the DV docket, the domestic violence. So Ben works domestic violence, I work adult custody. We are each responsible for half of the alphabet with regard to each of our types of bail. We are receiving emails constantly from defense counsel saying, well, how about this plan? How about that plan? How about this plan? Meanwhile, there are defense counsel there in person who are talking about potential bail plans in person while we're receiving all of these emails. This happens the morning of. Court starts, time's ticking down. Court starts before the judge at 10 a.m. Court begins, those emails continue, discussions with defense counsel continue, and when a matter is put into the docket before a judge, the court clerks will come and they'll put a piece of paper in front of us and they'll say, these ones just got put in. And what it means when they say this just got put in, it means defense counsel wants to run a bail hearing. So then you have to prepare your bail hearing that is going to proceed imminently. at that amount of notice, while you are still reviewing bail plans being proposed by defense counsel and speaking to them in person as well. And now court is on, and you're giving submissions to the court. So as you can tell, your attention is fragmented a million different ways, not a million different ways, but many different ways. And you're appearing in court, and we have to be up to date on everything that's happening. To set a larger background for everything that I've just said, there are hundreds of matters that each of us are responsible for on any given day. So to keep everything straight, to make sure we're not misappropriating facts from one file to another, making sure that when defense counsel proposes a bail plan, we've reviewed the previous bail plans that were proposed for that specific accused, making sure that the new bail plan is stricter or speaks to any of the issues that that individual had on bail previously, making sure that the criminal record is complete in case they've accrued more convictions since the last time they were released. There are many, many, many things that we need to check and ensure before we propose anything to the court, whether we are opposed or whether this bail plan is sufficient to protect the public. So that's what it looks like. Sometimes you will hear from defense, I'm going to put this matter in for a bail hearing, it should be in here in 10 minutes. Sometimes you don't get that, and we just hear from the clerks as the matter is being pulled up and the judge is ready to hear about it.
So you might start working on a bail application, that never happens. You'll like be using up
We-
resources.
We often find ourselves preparing for bails that aren't ever going to occur. Some of the most serious matters that we'll review will be ones where a bail application maybe isn't going to be very likely to be successful, but we need to prepare those because the public risk is the highest in those circumstances. And while we're preparing that bail, we're not preparing another bail that may be more likely to come up. So the challenge for us is just being prepared basically for everything that's in the bail triage court at all times, which is sort of not the best way for our attention to be focused. It would be better if we knew the day before what was coming and we could dig into it more substantively.
So how effectively can you do your job under these circumstances? I mean, it sounds like things would naturally fall through the cracks from time to time. I mean, it's
The Crown attorneys that appear in bail court are some of the most professional, competent people you've ever met, and they work exceptionally hard to stay on top of everything, but invariably the pressure is such that we just can't keep on top of everything, and we could do a better job if bail was done right, and we had the time to do it, and we had the resources, frankly, to look into plans. So, part of this is about procedure. Part of it is about having sufficient crowns in bail court to review these matters and to be prepared for them. And part of this is about having police resources in place so that we can vet these plans. Sometimes you'll have plans offered that essentially are to addresses that may or may not exist, or to addresses where ultimately if someone was able to go knock on the door and look into it, you would find out that the person living there, sometimes a family member who the accused says, yeah, I can live with them, says absolutely not, they can't live with me. And so we're stuck in a position sort of counting on the efforts of the defense lawyer to look into these plans. And often these defense lawyers, the articling students who do a lot of the work for defense firms, they're pulled in more places than we are in a lot of ways. And so they're doing their best to put these plans forward with very demanding clients. As we've said, it's a frenzied environment.
There are very small adjustments that could be made to the process that's in place that I suggest would have large impacts on the ability of the Crown to more fully carry out the many duties that it owes to the public, the court, and the accused.
So would you say that, and I guess not to put blame because it's a multifaceted issue, that there are people then in these instances that are getting out on bail that maybe shouldn't be?
I think ultimately what happens is the court isn't appraised of all the facts that they ought to be, and the decisions they make aren't necessarily the best ones that could be made if all information was before them. I think it would be a mistake to think that it's just about detaining people in custody. This is about better plans being brought forward that will actually do what is intended and keep the accused out of trouble while they're on release. So it may result in, the system we have is adversarial, and so the Crown advances a case and defense attempts to essentially contradict that case. And we're both made better by that sort of adversarial nature. And I think if the Crown was able to, if the Crown was able to make stronger arguments, defense would come forward with better plans, and we would ultimately see better results.
And to your question, I think the flip side of that is true as well. Individuals that maybe should be out that are being detained right now, the possibility exists for that as well, with proper bail release conditions in place.
Ben, do you know if other jurisdictions are using police resources to help investigate bail plans? I wonder if defense might raise an argument about conflict of interest or something like that with police, investigating people who they've already.
So my understanding is that there is some use in other jurisdictions. Brooke actually was a prosecutor in another jurisdiction, and she can actually speak to what happens in another jurisdiction.
Right, so I practiced as a Crown attorney as well as defense counsel in Saskatchewan for many years before coming to Manitoba. And the practice in Saskatchewan is that probation officers are the ones who vet bail plans. What they prepare there, it's called a judicial interim release report, and it's a third party who reviews the bail plan that's proposed to make sure things aren't happening like what Ben mentioned earlier, proposing an address to live in, that address doesn't actually exist, or suggesting this individual can be a surety. In reality, that surety isn't willing to act as a surety for this individual once again. So you have probation there taking on the role that we have proposed police do. The reason we're not proposing probation is that they're quite busy. And asking that they have an additional thing put on their plate may not be the fairest ask.
I guess you could say the same for police, they'd say we're very busy too.
Everybody is very busy, I think yeah.
I think as it relates to the police, they're the ones working these cases. They're out on the street, and certainly they're often best positioned to go investigate these things. Certainly the Crown attorneys appearing in bail court aren't in a position to do that.
What do you make of the national conversation on bail reform right now? I mean, it's a political talking point at every level of government, municipal, provincial, and federal. So what's your take on how that conversation is going?
It's an important conversation, and it's a legitimate conversation for people to have, and it's one that we're hoping to contribute something informed about. Certainly, what we hope to offer is a contribution to that discussion that's grounded in the law, that's grounded in sort of common sense about what procedures might make the most sense. But certainly, people are entitled to have their opinions, and this is a free and democratic society, and they ought to be able to express them. And so I think that's what we're seeing, and we want to contribute to that conversation and have it go in a good direction.
Has this been raised before, what you're talking about today, like through the back channels with the chief judge? You're talking about it publicly now, but has this been raised before?
So we've raised it today, and certainly we released the discussion paper we did this morning. We wanted to do that in a transparent manner to sort of all stakeholders. So not only did we send it to the court, but we sent it to the Criminal Defense Lawyers Association and some other stakeholders, because we think it's important to have that conversation transparently and not sort of through sort of back channels. We have a responsibility as Crown attorneys to be straightforward and upfront with the public and with all parties in court.
So what would need to be done, like this, I don't know if this is a silly question, but like, is it an easy fix to do that? Like, or would there need to be an overhaul of the?
Like, what's the process for changing it?
So what we're asking for is that requirement that defense counsel give 24 hours notice, and that could be done by way of the court issuing a practice directive. That is something that could be done today. Of course, it's a little bit unreasonable to say we're creating this practice directive and it's in effect tomorrow, but it's something that could be done in the here and now. This isn't a situation where we're saying there needs to be changes to the legislation or anything like that. When we're in bail court, we apply the law that exists at the time. We're simply speaking to the process that's in place in Winnipeg and asking that the court issue a directive that requires defense counsel to give Crown 24 hours notice so that when we walk into the courtroom, we know which bail hearings we're speaking to in advance and we can be adequately prepared.
In terms of how it might come about, it's fair to say that it would be the court that would initiate the process, and it would be up to them to decide to do that. And I think it's obvious that they would want to discuss with all stakeholders, not just Crown attorneys, but defense lawyers and police and other participants in the justice system. And so we're trying to start a conversation. We're not trying to tell anyone what they ought to do or ought not to do. We want to get the discussion going, and we want it to be a discussion that's thoughtful.
You said, Ben, that you basically have to be prepared for everything in the bail triage court at all times. Can you talk a bit more about what kind of load that places on you, having to be prepared for that volume?
So what that often means is you're preparing for many, many files. Most individuals who come to court, to the bail court, have been arrested and released once or twice or 3 times already. And at the point at which we're preparing to oppose their release, it means we're going through numerous files, and if we don't know which ones that we're dealing with, ultimately it means that we end up having to spend a lot of time in advance of court, in the evenings before the next day's court, preparing for it, and sort of perhaps unproductively preparing for matters that aren't going to go forward.
Your entire weekend is consumed by bail court. Every Crown attorney prepares for court differently, as does every defense counsel. So I can't speak to like a blanket way of preparing prior to stepping into court. Everybody does it differently. From personal experience, everything is put on hold. Family life, other files, it's all in on bail because that's what it requires from me personally. And to the point over here that was raised earlier, it is preparing for dozens and dozens of matters that don't see the light of day during that week.
And this is part of what Brooke's talking about is we still have our regular practice that we do when we're not in bail court. You're sort of assigned to bail court, maybe it's once a month or once every 2 months for a week-long period of time. You still, while you're in bail court, have to deal with your ongoing practice, and there are expectations around that. It poses a real challenge to Crown attorneys to stay on top of that, and it's all part of the larger issue we've been raising about Crown workloads, and certainly I think it's no surprise to most people in this room, we have a grievance about our workloads that continues to be ongoing. We hope to get that resolved, and resources, more Crown attorneys would help us with the issues we're raising, but so would changes to the procedure.
Why is the association jumping into the discussion now? Kind of what, was there a moment that made you say, okay, we need to step out and add our voice to the discussion?
Sorry. It's, as you've mentioned or alluded to, it is an ongoing discussion. Much of it is happening without, we're trying to provide the details of what bail court looks like for someone who's running bail court and presenting in bail court, so that when the discussion is ongoing in the public amongst members of the public, media, other people who are participating in the court process themselves, that we can all be dealing with the same information and that hopefully we can all have a constructive conversation going forward. So what we were attempting to do with releasing the information that we did is making sure that everybody is understanding of what the bail process actually looks like while it's ongoing here in Winnipeg, and then we can have discussions about it from hopefully an equal plane where we're all sharing the same information.
Do you think there are misconceptions maybe that are being kind of bandied about?
I think it's fair to say that there are perhaps some misconceptions about the bail system as it stands. The courtrooms would get full pretty quickly if everyone came down and watched, but we would encourage people to come see how bail happens, the good and the bad. There's a lot of serious consideration of every plan that happens, notwithstanding what we're saying. And I think the more you learn about the bail process, the more you understand the sort of ins and outs of it. I think it's fair to say that there's some apathy towards any change and some efforts to completely overturn things that are happening. And we want to just add our sort of knowledge to the conversation so that whatever conversation is happening, it's one that's well informed.
And then maybe last one for me, sorry to hog so many questions, but I'm sure you saw Mayor Scott Gillingham has put together this weekly bulletin that he's doing where he's like giving examples of repeat offenders and putting that out in the public eye to kind of advance his argument for bail reform at the federal level. What is your take of this move that the mayor has undertaken?
Sorry.
Oh, go ahead.
It's public information. There's nothing offside of putting that information out. It's available to anybody to look at it and share it how they wish to do so. This is how he's choosing to do that. And our focus here is on more of what we have. We're not asking the federal government to do anything. We're just seeking our court to impose a practice directive, which feels a little bit more feasible.
I think it's fair to say that the mayor has his prerogative to release that information, and as Brooke says, it certainly is publicly available information. It's not something that we would routinely do. We think our arguments about individual cases are best left for the court.
The two recommendations that you made in the discussion paper, you said they seem pretty feasible. Is there anything else that you need beyond those two seemingly very attainable things?
I think it's fair to say that in terms of court process review, certainly there's probably more things that could be discussed as a larger group of people get involved in that discussion. What I think we really need is the resources to get the job done. And certainly, not to harp on this too much, certainly that's an issue we've been raising for some time, that Crown attorneys are overburdened with work and that we need more resources. We need more Crown attorneys.
Has there been any, I know you mentioned a couple minutes ago your grievances with the province, have there been any updates on that one, staffing or the others?
There's an ongoing discussion we're having. Obviously, the grievance hearing is at the end of October. We're certainly hoping that we can come to some kind of agreement to resolve that grievance. And it's fair to say it's an ongoing conversation, but right now it's not resolved. So it's certainly something that we think is important for the public to be aware of what we're calling for.
And this one might be a little bit repetitive, but just to sort of sum up when we talk about these public discussions we've been seeing about bail reform, what do you hope to help the public understand about how some of those calls might affect Crowns and their workload specifically?
Sorry, can you repeat that?
Just the general bail reform, we need to lock people up, sort of tough on crime rhetoric. What do you think the public needs to understand about how, like we've seen things like the 3 strikes, those kind of ideas, how would that affect Crowns and their workload?
Yeah.
I think the discussion is going to be ongoing between politicians and citizens. What we can offer is what we know about the system. We hope that the information we provided in the discussion paper is informative in that regard. Ultimately, the public, and we're all voters, get to decide what's important to them, and we leave it to Parliament to decide what the law of bail is in Canada, but we think we have something to add in terms of just how the process works.
Ben, what's the next step here, basically? You guys have put out the discussion paper. Is there a hope to get a response from somebody, or, like, I guess, what do you guys envision as coming in the next few days or weeks or months or whatever that timeline is?
I think we're hoping to have a discussion with stakeholders. We're certainly open to that, and we hope the court will engage with this discussion paper. We're trying to start a discussion, so we hope that discussion happens. It's obviously the court that decides.
Have you talked to any defense attorneys about this and what their thoughts are?
Certainly, by releasing this today, our attempt is to start that conversation, and we wanted to release it to all parties at the same time. Certainly, I think we'll start that, and I'm sure as the days go by, I'll have lots of people coming to talk to me about it if they weren't already talking to me about bail. They see me in bail court when I am in there, and certainly, I imagine we'll continue to talk.
Sorry, you said bail can come up day of. Can you give us an example of, like, what's the quickest you've ever had to prepare for one of those cases?
No notice.
Essentially, you have situations where court starts at 10, so you may have matters that are starting at 10, and you're arguing those before the court, and even when you're not arguing, you're listening to what counsel's saying, or you're listening, defense counsel saying, or listening to the judge, and you may get another one coming in right after that. That is essentially going to be the next one or the one after the next one. So it's hard to stay on top of that. You've hopefully read that in advance because you've been preparing the night before, the weekend before, but that's not always the case. And to be clear, sometimes we get no notice, sometimes we do get a fair bit of notice, but it's a courtesy that's afforded to us by counsel when they do that. It's not a requirement, and so it's this tough tension. I think a lot of defense counsel do respect that it's best for us to have some advance notice of what's happening, but sometimes these decisions to make an application for bail are made very quickly, and it's an oversight or it's just not something that they're able to do. This would require that to happen and make sure the process is happening in a deliberative way.
And in circumstances like that, what that you just described, are there cases where a bail application comes to you like out of nowhere that you have no knowledge of at all, or very little knowledge of because you didn't have time to get to it, or it just wasn't brought to you beforehand?
Absolutely, that can happen, and in those circumstances, as the Crown Attorney, if you feel like you know nothing about this and you are so ill-equipped to give submissions to the court, we ask the court, we say, we haven't heard about this, we need time to review this, as much time as you will allow us to do that before we speak to it before the court. It's not our decision whether or not we get that time.
And how much time are we talking? Are you talking like, give me an extra half an hour? It's not a 24-hour.
Something like that.
It's more like, tonight,
There-
can you give me 20 minutes?
What I'll say is there are mechanisms in the code that do allow us to ask for an adjournment for 1 day, 2 days, or 3 days, but we use those sparingly because if we're constantly asking for that, the court's going to start asking us questions about why we're not prepared. So it's not to say that we don't ask for a day in some cases, but it doesn't mean that that bail runs the next day. It might just get moved to another day. So the unpredictability of that is there regardless.
And to your knowledge, has it always operated like that, like this in Manitoba?
So the current system we have with the sort of bail triage court that's in courtroom 301 and then the 2 judges court, this way, it's basically operated this way since COVID-19. It operated somewhat similarly before that. There are often modest changes, but the sort of notice periods have been a long-standing issue, I think, for the Crown. It's heightened during sort of the period of post-COVID-19. There was changes, so there were changes in about 2020 to how this was going because a lot of matters were appearing by phone during that period of time, and so this precise process has been around for about 5 years, but it certainly has been like this more generally for a long time. Any other questions? All right, thank you.